Hello again, everyone. I'm attorney Robert Flessas, and thanks for taking the time to view this video. Today, I'm going to talk about damages that can possibly be taken in an eviction lawsuit by way of a damage judgment. Now remember, every state and in some cases local municipal codes handle damages differently from jurisdiction to jurisdiction. If you're a renter, you'll want to familiarize yourself with the applicable laws where you reside before you rent. For that reason, I'm going to discuss this topic in general terms because I can't cover all of the laws in each state. I'm making you aware of the possible damages that may be had by a landlord. Let's start with the most obvious and common damage claim by a landlord in an eviction. That would be physical damage to a rental unit, like holes in the wall, damaged carpeting, broken windows, busted doors, dirty kitchen, appliances that don't work any longer, baths that are dirty, and leaving personal property and garbage in and around the unit after vacating. A landlord may have the right to charge you for labor and material costs to correct the damage caused to their unit. In some jurisdictions, like the one I practice in, the state law allows the landlord to charge for even their reasonable time to perform repairs and cleanup tasks, whether they hire a contractor or not. Another type of damage is unpaid rent. Each state may handle unpaid rent differently. In the jurisdiction where I practice, state law allows landlords to charge double daily rent beginning from the expiration of the 5-day notice to vacate until the tenant actually vacates the unit. Another type of damage is the landlord's cost to bring the eviction action. That's called a filing fee. Whenever an action is filed with a court, the landlord must pay to the clerk of courts a filing fee, and in my jurisdiction, the cost is over $100. Once the case is filed, the law requires the landlord to serve notice of the lawsuit on the tenant so that the tenant knows they're being sued for eviction. That cost varies depending on who serves the papers to the tenant. The sheriff will usually charge more than a private process server to deliver the documents to the tenant. Another cost could be attorney's fees. If the landlord hires an attorney to prosecute the eviction, most courts allow the actual attorney fee or reasonable attorney fee or the statutory attorney fee to be tacked onto a judgment. If the tenant doesn't vacate voluntarily after a judgment of eviction, the landlord may have to employ the services of a moving company to remove the tenant's personal property from the unit. Movers can be expensive because they usually charge by the hour. In my jurisdiction, they allow landlords to perform that task without the assistance of a mover, but most landlords hire a mover anyway to avoid liability for damage to the tenant's personal property when removing it from the unit. Courts require the landlord to prove their damages before receiving a judgment with evidence, including pictures and invoices. Due process requires the tenant to have their say in court regarding the damages. The landlord just can't walk into court and obtain a judgment for whatever damage they claim against the tenant. But if the tenant fails to show up for the court hearing on damages, then the court will most likely grant damages to the landlord. However, some jurisdictions may still review the claimed damages presented by the landlord without the tenant being present to verify that the damages are reasonable and statutorily allowed. So it's a good idea in an eviction action to appear at not only the first eviction hearing date, but any subsequent damages hearing date that is scheduled to defend yourself. In previous videos, I talked about why it's a good practice for a tenant to take pictures of the unit, not only when they move in, but when they vacate the unit. And here's the reason why. You can bet that in a damage hearing, the landlord is going to take pictures of the way that the unit was left and show those pictures to the court to prove that the damage exists. A tenant could use their pictures of how the unit was delivered to the landlord when the tenant vacated to rebut. For a tenant, it's not a bad idea to keep good records of defective appliances, doors, windows in the event that the landlord attempts to charge a tenant for damage that existed and was never repaired in the first place. There are things that a landlord can't charge for, like normal wear and tear to carpeting or flooring, but you really need to check check your local or state laws to see what types of charges are prohibited in rental contracts. The bottom line is that a damage hearing could result in the court granting a judgment against the tenant for sometimes thousands of dollars. That judgment is placed on a public court record. If a friend or relative co-signed on the lease, they could be liable for the damages too. The public court record goes on the credit report of a tenant, and this damages the tenant's credit score. It will certainly affect a person's ability to rent another unit in the future as well. The record will show that a tenant applicant doesn't pay their rent and, more importantly, damages property. Do you think another landlord will rent to that person? With an existing judgment, if a tenant wants to purchase a home in the future, the judgment will most likely have to be paid, including interest, before a former tenant can purchase a home. Watch some of my other landlord-tenant videos to learn more about the law as it applies to landlords and tenants. When you rent, either as a landlord or tenant, you should always check your local laws to learn your rights. I'm attorney Robert Flessas, and thanks for watching.